This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight it's Ask Us Anything night, just in time for the new year. If your New Year's resolution includes getting something resolved, something legal, whether it's getting a will taken care of a car accident case, or resolving something with an insurance company that's been bothering you, call in your questions. It's Ask Us Anything night. The 31 Law Call number 256-536-0077. You can call in and ask live on the air, or you can now text us to that number. We have some of your text ready to go as well. You can also email a question. You can email a question on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we pull some out. We've got some of your email questions ready to go tonight. We've also got Heath Brooks here from Timberlake League and Brooks ready to go tonight to answer questions. Ask Us Anything night, always our favorite, because you just don't know what might be coming
That's
in.
right. You know, call, ask us anything. We're wide open tonight. You can ask us anything you need to ask us concerning the law, and we'll do the best we can to get you an answer.
These guys do personal injury law, so that's everything from car accidents, nursing home negligence. We'll talk about some of those because you've got some tough cases going on. Injuries, people in big stores where a door may collapse. Any kind of question, call in tonight. And we like to start us off while we get our phones locked in with a clip. Tonight's You Make the Law Call video is this one on the road. Wouldn't it be great if you could handle all your legal problems with just a video and solve everything, if everything were recorded? It's the blue car. Of course it's the blue car that's speeding out of control.
Goodness.
So when you're driving like that, first off, he shouldn't be. But when somebody around you is driving like that, talk about the legal aspects of that. And it may even play into some workers' comp issues or things if you're on the road and something like this happens to you while you're on the job.
You know, this is just the interstates, people being crazy on the interstates, driving way too fast. You know, not being able to see what's up ahead of them, cutting off in front of other cars. You got a difference between what is negligent, meaning that you're not acting reasonably, maybe you violate a statute, and then what is reckless, where you are just taking an action that you know is unsafe to everyone else on the road, and you're just doing it anyway. And then you cause that kind of wreck, that kind of turmoil. I have a good friend of mine who witnessed a wreck on an interstate not long ago, where an individual just was on the outside lane, decided just to come over in front of someone else without looking, and caused a massive pileup on the road, and he just didn't look. He didn't pay attention. You know, he didn't know what was coming, where he was going, and caused a massive collision that my friend happened to witness and was able to avoid. But when you get on the interstates like this and you see people flying around it, I was raised and my teeth were cut driving in Atlanta traffic.
Oh, geez,
so you have people zipping in and out of you. You don't know what's in front of you. People are driving too fast, and these kinds of accidents happen. And a lot of times it's negligence, and that's one thing, but then sometimes it is reckless conduct, and that's a whole different ballgame when you take those kinds of actions.
Why? How does it affect the case?
You have different types of damages. So in a negligence case where somebody is run a stop sign on accident, we make a mistake, it's just an accident, then the person they hurt can be entitled to medical bills, lost wages, maybe they can be entitled to permanent injuries that they have, the pain and the suffering, the mental anguish. But when you have exhibited reckless conduct, when you're driving way too fast through a school zone and hurt somebody, or when you're driving like this crazy fellow was on the road on an interstate, then you can be entitled, as the person who was injured, to punitive damages. And punitive damages, sole person, is the civil way of keeping anyone else on the roadway from doing those kinds of actions ever again.
We have got Alan on the line with a question from Town Creek. Hi, Alan. Thanks for calling. What's your question tonight? Hey, Alan, are you with us? Alan from Town Creek, thanks for calling in. Have we still got you?
Yes, ma'am.
Hi there. Thanks,
Alan.
Thanks for calling.
I have a question about an easement.
Okay, an easement. What's going on?
Well, we've been in this situation for the last 5 years, and the easement that's traveled through our lane was just surveyed within the last month. And the survey came out different than the easement that he travels.
Okay.
So basically he's traveling our property.
Right.
So the plaintiff's attorney filed an amendment. He filed an motion to alter, amend, and vacate. And he filed this on a Friday at noon, and the following Monday, he had the judge amend final order. I thought we was allowed to make a response on that order before she would do that 3 days later. Plus, we was never notified of this order from the attorney, and we had no way to respond because, you know, Saturday the mail comes out, Sunday they don't deliver mail.
I understand.
Sure.
And Monday she already made a decision.
Sure. That's fast.
Alan, what county are you in?
I'm in Lawrence County.
Okay. All right, so generally in those kinds of scenarios, you're exactly right. You do have an opportunity to respond to a motion. And what you need to do now is, because you didn't have an opportunity to respond, I would strongly suggest you talk to a lawyer and retain a lawyer that can file that same sort of motion that was filed against you. It's called a motion to vacate the order, a motion to vacate the judgment, and you'll file that, and you need to have an answer ready. Your motion should say something like the motion to vacate the order, and then that you're fully prepared to answer and to brief the court on the issues that are presented. And so a lot of times you're going to need a lawyer to do that. You've got a weird issue with an easement. You know, that gives somebody the right to pass over your land in the drawn up on the plot, the land plot, or the deed, through those lines that are drawn on that deed. And if it's outside of those lines, then they're not going down, they're not traversing over the correct easement. And so you have a right to move that easement, because technically you own the easement. You're just required by law to allow somebody to travel through it. So you know that there are some legal issues that can come into play, particularly if that easement has been used and used and used over the last however many years. So I would strongly suggest you contact a lawyer and have that lawyer answer that motion for you.
And quickly, right?
And quickly. Don't sit on it, because if you sit on it and you wait a serious amount of time, then what's going to happen is the judge is going to say, hey, look, you would have had this opportunity anyway. You didn't do what you needed as quickly as you should have done it, and we're all moving on with our lives.
Okay. We've got Kelly on the line with a question from Newmarket. Hi, Kelly. Thanks for calling. What's your question tonight?
So a couple of weeks ago, I was in Madison, and one of the big box stores came up beside me, and a rock come out from under it and hit the window of my car.
Gotcha.
And it cracked it a little bit. And so my son got a picture of the truck and the truck number. Well, I called them, and they told me that they weren't responsible for it. But yet, it come off their truck.
And you're certain of it, and you saw it. What do you think?
Yes.
Yeah.
Yes.
Yeah, there's a difference. There's a difference there, Kelly. One is that, okay, did the rock come from the road so that the truck pushed the rock off of the road and into your window? And in that kind of scenario, then they are probably not going to be responsible for any kind of damage that happened for your car. But if something came off of their truck, if a rock came off of their truck, we see it all the time with the type of trucks that carry the ladders that are attached, or concrete trucks, or trucks that do carry gravel specifically. And they'll have that sign, stay back however many feet, and not responsible for stuff that leaves our truck. That is absolutely not true. If something comes off of their truck and causes damage to your car, then they are responsible for that damage because it was not properly secured, and that is negligent conduct. And I would say, you can take one of two steps there. The first step is to just say, okay, well, I got a cracked windshield. It's not worth it to put the time, the money, and the effort into trying to get them to pay me. The other thing is you could go down to the small claims court, which is on the 8th floor of the Madison County Courthouse, and file small claims action against the company.
Because getting an attorney to take the case for a cracked windshield, we're talking several $100s.
That's right.
But it's probably not enough for a lawyer to take it, and you want to pay a lawyer to take it.
I think that it's one of those things that you call a lawyer, like the kind of work that I do. We will be happy to give you advice, but it's going to cost more. You're going to be putting good money after bad. It's going to cost more in the end, because you're going to pay a lawyer a percentage of what you collect. We don't charge a nickel for any kind of law, we practice for you unless we recover for you, and then we take a percentage of what we collect. That's called a contingency arrangement. And so sometimes it makes a whole bunch better sense for you to try to resolve that claim with a lawyer's advice, that claim on your own, just because it's going to cost more in the end than what you could get on your own. So, you know, in a small claims action, you can get your attorneys, you can get your cost of court back and things of that nature if you end up winning.
We've got Brenda on the line with a question from Danville. Hi, Brenda. Thanks for calling. What's your question tonight?
Yes, I've had home repairs done in 21.
Okay.
And the people that done it come in. They supposed to have done the floors, repaired them, and leveled them. And we found out about 3 weeks ago I had my bathroom underneath, had to have a new bathtub, and some wood had rotten.
Okay.
And the person that fixed it, he got under there and he seen where the people had nailed good lumber to the termite wood, and they've left the wood under there. He hadn't even put it up on top of the floor, left it on the ground, and then they put the barrier, the black paper that's supposed to be plastic, supposed to help the barrier under there.
Yep.
They just put it around the edge of the house and didn't even put it in the middle of the house. And see, I've had, I got to have a knee replacement. My husband's had a stroke, and we paid him $8,000 up front.
Yep.
And then we gave him $7,000 more when they finished. And the house is not, they haven't done their job.
Brenda, was this in your bathroom, you said?
Well, the bathroom's where we had to repair for the rotten wood under our bathtub. We had to put in a new bathtub and some new flooring.
Okay, you know, Here's the thing about water damage in a house, particularly after you have somebody that has come in and repaired your house. You know, you have a duty as somebody who is going to come in and perform services on your house, that they are going to do it with a warranty of merchantability, that they're going to do it and it's going the work is going to be good, it's going to be good craftsmanship, good workmanship, and that if it's not good craftsmanship and it's not good workmanship, then you can file what's called a breach of contract action against them. You may be entitled to some damages that flow from the damages their work caused as well. There's a couple of things that you do need to know, though. First off, there could be some time limits in this type of case that you really need to be aware of. If their conduct was negligent, then you have a 2-year statute of limitations. That means you have a 2-year time limit to bring an action against them. And there are some nuances to that could extend your time limit in that kind of scenario, but you need to be very, very aware of your time limits. The other thing is that this is a very common problem, particularly when you're dealing with bathtubs and with tile showers. In a different world, in a different life, I did some of this work. And one of the things that you have to make sure you do when you're doing this kind of work is you got to put in the barrier right. And if you don't, water will leak through. You won't be able to find it because it'll slowly rot out that wood. And by the time you do find it, it's years down the road. The floor's all rotten out and your feet are about to go through to the ground. So it could be a serious issue. If you paid somebody a bunch of money to do some work for you and then they were negligent in doing it, or if their work wasn't good, you do have a potential cause of action against them.
We're going to take a break. We'll be right back answering any of your questions. It's Ask Us Anything night, so stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back tonight. It's Ask Us Anything night. Heath Brooks is here from Timberlake, League & Brooks. They are personal injury attorneys, so that's everything from nursing home negligence to car accidents, and we've got callers waiting. We've got our first of 2 Lisas on the line. Hi, Lisa from Huntsville. How are you? Thanks for calling. What's your question tonight? Hi.
I just was wondering, I know someone that's in jail, and they have a hold on them, and it says in capital letters DECT. Does that mean Decatur by chance, or is that might have a hold on her, or what? I don't know. I've never seen that one.
That could be the place where it's being held. That could very well be Decatur. Is it in a piece of paper you got at your house, or is that something that they've gotten at their house, or some family member has been alerted to this, or an online search?
No, it was an online search.
Okay, yeah, that could be the location of where they are. I mean, the best thing to do, or what you could do, is you just call the local district attorney and ask them what that acronym means, or what the location. That's probably a location, or where it's either a location of where they're being held, or it could be a location of where in the what area of that particular jail they're being held in. But you call a local district attorney.
And most of our local county jails have got an inmate search feature, so you can search Madison County and actually search by name. And I want to say Decatur, or some of our other counties have got searches by name, so you may want to try Morgan County.
Morgan County does. That's exactly
Good luck
right.
with it, Lisa. How about Lisa number 2 from Huntsville? Hi, thanks for calling. What's your question?
Hi. Yes, my mother passed away in 2022.
I'm sorry.
And we had an estate lawyer and that we worked with to get everything took care of. And I got a notice that he sent me a letter saying he received some payment from a trust from this year.
Mm-hmm.
And we haven't had anything this year. In September 16th, he said the amount of $83. And I don't know why that came to me, because everything has been done.
$83 lingering out there.
My thought would be, and Lisa, I don't know what the circumstances dealing with setting up the estate and winding down the estate of your mama, but my thought would be is that there was some money that may have been paid. As attorneys, we have to keep what's called an IOLTA trust account, and in that IOLTA trust account, we have to, if you pay your lawyer a retainer, then for whatever services, well, probably what happened is he put that money into a retainer, and out of that retainer, he or she takes their hourly rate out of the retainer. And if there's any money left over in that trust account, then you're entitled to get that money back. And this is just me thinking, but my guess is that money came from the IOLTA trust account that had been set up for you folks, and that's just your attorney winding that trust account down.
Good luck with it, though. Call him, ask him. They ought to be able to give you a quick and easy answer on that one. We got this text question in, so you can always text us at the number that's on the screen. Would it benefit my children to transfer my property over to my children so they wouldn't have to pay inheritance tax?
So, inheritance tax can be, I think right now the rate is $5 million before you have to worry about inheritance tax. And if you've got that kind of an estate that's a multi-million-dollar estate like that, then it could benefit you early in life of transferring over some of that property. But then again, you can only gift a certain amount every year to anyone else without it being taxable to them. So I think it's $10,000. They may have raised it to $20,000 a person now that you can gift to your children in any one calendar year that doesn't have tax implications. So that's a consideration too. The last consideration is if you don't have a multi-million-dollar estate, then there's probably no reason to transfer over any property, while you're living. Sometimes what ends up happening is if you don't have end-of-life care set up, in other words, if you don't have insurance to go into a nursing facility, and you have to go into the nursing facility and take advantage of Medicare or Medicaid rather, if you transfer your property within I believe it's a calendar year, maybe 24 months. Prior to you needing Medicaid, Medicaid can claw that back if you give it to your kids. So that's another consideration that to think about when transferring property to your children. Sometimes you can do it too late in your life to where the government could get it back. Other times it just doesn't benefit you.
I think they may be able to look back even 5 years in some cases.
Yeah, I think you're right.
But if you transfer over your property to your children, you better trust your children, right? And they're debtors. I mean, if somebody can come after that property that you've given to your child, you don't have control over it anymore. So be thoughtful about that before you really do it. We've got Jerry on the line with a question from Madison County. Hi, Jerry. Thanks for calling. What's your question tonight?
Hi, how you doing?
Good. How are you?
Hey, Jerry.
All right. I have a question. What can be done when someone locks you away in a mental hospital with no with not having any mental illness or anything, but they lock you away.
Lock you away in a mental hospital.
Okay.
I would think the doctors would be performing some tests on her.
That's right. You know,
No.
you can be involuntarily placed into a mental institution. That has to be through a doctor's order, sometimes through a court order, before that can even happen. Otherwise, if the court has not ordered you through a doctor's note that you can be involuntarily committed to a mental institution, then you are not involuntarily committed. You would have to be voluntary. You would have to voluntarily check yourself in. And if you have not voluntarily checked yourself in, and the court has not, and you have not been involuntarily committed, in other words, committed against your will, then you're being held as a prisoner, and there's a problem there.
Okay. We've got Curtis on the line with a question from Decatur. Hi, Curtis. Thanks for calling. What's your question tonight? Hey, Curtis, just listen through your phone. You'll get a little delay there otherwise. What's your question tonight?
Can you hear me? Okay. What it is, my family got some land.
Yes, sir. Just listen through your
All
phone.
right, I can hear how. Okay. What it is, my family got we've been from family land, and I've been taking care of it.
Yes, sir.
I've been taking care of it for over 30 years, cutting the grass, and then since I've been sick, I'm paying folks to cut the grass and all that kind of stuff.
Okay.
And so what I want to get it deeded in my name. Do I have to go through the whole family? Most of them are dead, and most of them live out of town.
And I think they said he's been paying the taxes too.
It could be complicated. You know, you can actually. I mean, if you've been taking care of the land, it's been abandoned. First things first, Curtis. You probably need to get with a lawyer to talk about this. Land cases can be incredibly difficult, particularly if there's a bunch of different people who are heirs, and the title they call it quieting the title. In other words, if the title to this property is still in somebody that's a name that is no longer with us, and there's a bunch of different family members all over the country and in different parts of the world that have a potential claim on this land, then the title needs to be quieted, and that needs to be you have to do that to go through the court. So it's not just as easy as just setting up a deed. That is a significant legal process you have to go through. Now, that being said, because you've been paying the taxes, because you've been upkeeping the land, you can request that amount back from the other potential landowners. So get your attorney. Serious legal issue there.
Good luck with that. We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. If you didn't get your questions answered tonight, here's how to get in touch with Heath Brooks with Timberlake League and Brooks, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon W. practices family law. That's divorces, child custody, all things family related. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
Thanks for all your calls and questions. We'll see you next week.
Have a good night.